SJC-11902, Katz, Nannis, and Solomon, PC, and others, v. Bruce C. Levine, and others.
Good morning, Mr. Carey.
Good morning, Your Honor. Tom Carey for the appellants, and may it please the court. This case presents the court with the issue whether the parties to an arbitration agreement may contract for judicial review of the merits of the arbitrator's decision in the state courts of Massachusetts.
Mr. Carey, could I stop you there
Certainly.
I'm a little confused. Are you saying that absent this heightened standard of judicial review, your client loses if it's
No.
the ordinary standard of judicial review?
No, we make all of the arguments under the ordinary standard of judicial review.
So we don't
seems-
have to go to the question of whether or not the enhanced standard of review is
Yes,
in place, whether the arbitrator's authority constituted material, the action of the arbitrator constituted material, gross and flagrant error. We don't really even have to reach that.
that's correct. If you were to give us all the relief we're asking for under the standard review on Chapter 251, you could duck the issue.
And that would be because the arbitrator exceeded the scope of his authority? Is that what grounds all of your arguments?
Yes, all exceeding authority, providing a remedy not provided for in the agreement,
So that's again exceeding the scope, no?
and sometimes it's, the cases, as you know, get pretty complex at some of the dividing points. Is it exceeding the authority, or is it legitimately interpreting the contract? Is it exceeding authority because the remedy wasn't provided for in the agreement, or is it against public policy because you're attempting to enforce a remedy that's not provided for and that is prohibited by policy?
So are you saying that it's both of those? It's
We
public
argued-
policy as well as beyond the scope?
Yes. Our brief argues that this ruling should be reversed on the standard grounds. We recognize that some of those arguments are clearly debatable. They're in those areas where the line is fuzzy, whether you're going to interfere with the arbitrator or not. In this particular case, the parties provided for a standard of review that's broader than what is in 251.
Could I, on that point, you cite a case from the Texas Supreme Court and an Alabama Supreme Court, and I'm just wondering if one were to look at the country where a majority of, I mean, the Supreme Court has said what it says about the Federal Arbitration Act,
Right.
where the rest of the states are. If you can-
We did the best we could in addition to our own research.
I know, I'm just wondering if you could tell, I mean, I know you talked about it, but I'm just, if you
Yeah,
could trace it.
I don't think that there is a magnitude of enough cases to know whether there's a definitive tilt one way or another. One guide would be the Uniform Commissioners on State Laws have promulgated a new version of the Arbitration Act, 2000 Act. It's actually pending in the Massachusetts legislature now. There's been a hearing. The position that the Uniform Commissioners took on this issue was, we're going to punt. We're going to say, there was an argument you should put into the act an opt-in box that you could check for broader judicial review. And the commission has said, given all the confusion, we're not sure that's a good idea. We're not going to put it in the box. But, they said quite clearly, it is still free. The parties are free to provide for this if they wish. And if the courts want to enforce it, it's fine with us. When they wrote that comment, there was still a preemption problem with the Supreme Court. But Hall Street clearly says that they're not going to preempt this issue. They're going to leave it to the states. So there is no preemption issue with the state court concluding that it will enforce a broader review proceeding.
On that point, given the similarity of the Massachusetts Arbitration Act 251 follows pretty closely the Federal Arbitration Act in terms of the progress of provisions. So shouldn't we be reading, or should we be reading in a legislative intent to hew to the federal interpretation? That is, you can't go beyond what Section 12 says with respect to challenging an arbitration?
No, for several reasons. But all of these statutes came out of a reform matter back a long time ago. So they have similar genetics, but there are differences. And the history of the interpretation of the Federal Arbitration Act is a convoluted one, to say the least, and a contentious one in the views of many people.
Well, certainly now, on a lot of other fronts, absolutely, but that's not
Yes.
what we're talking about here.
Well, I know of nothing that would suggest that the Massachusetts legislature intended to instruct this court to construe the Mass Act the same as the Federal Act. Okay. What they do, because it's a uniform state act, is try to construe it uniformly among the states, and the states are split. The better reasoned decisions, the Texas case is post-Hall Street, and cert was denied. Cert says nothing about the merits, but it says they weren't mad enough at it to take it up. The California case is extremely well-reasoned and goes through a whole bunch of the background and issues of arbitration. And this court has freely interpreted the Massachusetts Act itself. It did not feel bound in the McGinnis LPL case to follow the interpretation of the FAA that you felt compelled to do under the Supreme Court decisions. But there was an issue of whether you would independently construe the state act the same, and you said no. So, no, I don't believe it has to be followed. If you look at the cases that refuse to create the new review, some of them just slavishly follow the reasoning in Hall Street. We rely on the detailed critiques of that reasoning in the cases we cite to suggest you shouldn't follow it.
So we would have to basically, though, because this standard is not something in the contract that the arbitrator could construe. The courts would have to construe what the language in the arbitration agreement meant in terms of this broader standard of review. And if there was anything ambiguous about it, because it was not defined in the agreement, as I don't think it is in this agreement, then that would be something that the judge would have to basically take extrinsic testimony on to find out what the parties intended by this language. Because I look at material, gross, and flagrant error. There are two different views being given of this. It's not defined in the agreement. And it also suggests that courts will each time have a different standard of review, and what it means could be varied, and the case law would not develop in a uniform fashion because parties could provide for different standards of review. There are problems with this.
You list some of the potential ones. I think they're entirely manageable. For example, you're constitutionally required to answer questions sent to you by certain executive offices and the legislature. You have had no problems historically telling them that's not the kind of question we're going to answer. The cases that have adopted broader review have made it clear that all you're going to be able to get is what we would usually give you. There's a great line by Chief Judge Kaczynski out west in which he says, "We wouldn't enforce a provision that said you should decide it by flipping a coin or studying the entrails of a fowl," going back to Roman mythology. All of those courts have made it very clear. Aberrant standards of review we're not going to do. Routine stuff we will. And most of these forms, what people are asking for is quite clear. We want judicial review of the law, and we want some kind of a review, clearly erroneous, however you describe it, of a really aberrant facts section. And I think
I must say, it's not self-evident to me what this standard of review means. So what would I do if I was the trial judge and had this?
or sitting here as you are now, I think you would say that is asking the court to review the legal rulings that the fellow made, that they have to be material to the outcome, not just something that someone's looking for an advisory opinion on. That, for example, in this integrated written agreement, the construction of it to create a non-competition clause that we contend can't be found in the language would be an error of law subject to review in the court. In the cases that have talked about the various problems, if you adopt this, most of them point out that there has in fact been no problem in applying it. Take, for example, arbitration itself. Some people, in this case, the parties opted for discovery and a reasoned decision. In other cases, someone might say, no discovery, no reasoned decision, we'll come in and talk to you like the wise man under the tree and tell us who owes what. If that's the way the arbitration was done, there's nothing to review for the courts. Every court that has accepted the notion that if the parties agree by contract, as they have a right to do, to arbitrate, they can set the terms of the arbitration, and as part of their contractual rights, they can say, we want the arbitrator's decision to be reviewed in the court system provided by the state.
But where is I'm looking at 251, Section 12. Upon application of a party, the court shall vacate an award if, and it mentions five, the usual five.
Yes.
It doesn't say if, number 6, the agreement runs contrary to an agreement by the parties for judicial review. So where is the authority of a judge statutorily to vacate an award?
It's not a statutory authority. It's a common law authority granted by the law of contracts, and it's not prohibited by the statute.
So you would say that now we're outside of Section 12. This is a common law right that would be wholly separate from, doesn't Section 12 set the terms for the review of an arbitration award?
It sets the terms for review of an arbitration award under the statute, and as here, it would ordinarily be the vehicle. Someone moves to confirm, someone moves to vacate. But if you look at the language of this arbitration, A160, after the proviso, provided, however, solely in the event of a material, gross, and flagrant error by the arbitrator, such decision shall be subject to review in court. And it goes on to say, any litigation must be brought in the state courts of the Commonwealth. All parties submit to jurisdiction. Each waives right to trial by jury. And then there's a provision for attorney's fees. So I think it did contemplate a declaratory judgment action. But the issue is that, the way the cases that accept this describe it is they say arbitration and the whole arbitration industry is a creature of contract to begin with. We enforce all of these because of the basic contractual principle that one enforces the agreement of the parties, and they agreed to arbitrate in a certain arbitrable process, and we'll enforce that. The states that accept the notion of broader review than the statute provides just take that to its proper conclusion. We'll do the same thing as to review. Now, on the merits here, I would suggest it's an important issue broadly. I think it's directly presented in the case. I think it's a good opportunity for the court to address it. The problem of a whole area of law being developed separately in private arbitrations without any input from the common law lawmaking policies of the appellate courts will ultimately cause severe difficulties.
Isn't that the choice that parties make when they do private
No,
arbitration?
if the legislature, yes, they can make that choice. All they have to do is not put the clause in.
They don't have to go to court, and so they go to arbitration.
Right, but if they say we want to go to arbitration, but we don't want to lose that opportunity ultimately, if we get a really aberrant legal ruling that's going to disrupt our business for years in the future, we want the option to go to the court. There's no reason we should deny them that.
Well, I think there are some reasons we should deny them.
The convenience of the court or impact on arbitration?
How are you going to have uniform case law developed that way either?
If enough cases come to the court system, then you will at least be influencing the development of the law. We do arbitrations nowadays that are full-blown trials. They have discovery, we have reporters, we court reporters, we do everything.
So should courts then basically say, but you didn't do that arbitration by using the rules of evidence? And so you didn't use the rules of evidence, and that's a very big problem. The difficulty with superimposing judicial review on a non-judicial process seems to me to be problematic.
If the parties choose, well, first of all, you're reviewing agency decisions right and left that aren't following the rules of evidence.
Say we must, and they give a standard for doing
No,
it.
I understand that, but obviously, my point is simply that the absence of the formal rules of evidence doesn't convert the thing into something that's so bizarre that you can't review the legal errors. That's my only point.
Okay, thank you.
Thank you, counsel.
May it please the court. Warren Hutcherson for the appellees, with me, Nancy Reamer. On behalf of Katz, Nannis, Solomon, and its shareholders, we ask this court to affirm the Superior Court's judgment confirming the arbitration award and the award of attorney's fees. The arbitration award issued by the Honorable Frank Williams, who was the prior Chief Justice of the Rhode Island Supreme Court, and before that, a trial justice in the Superior Court of Rhode Island, as well as Justice Brady's decision reviewing that, I suggest are unassailable on any standards applicable, and they certainly can't be vacated under the legislative standard under Chapter 251. Indeed, I suggest that if the arbitration award were a jury verdict or an award under Rule 52, this court would have no problems in affirming the judgment that was entered. I will address the expanded review, even though, as our brief indicates, and I'll address it in more detail, the language of the agreement does not even create a heightened standard of judicial review.
Well, you say that, but I don't know that your interpretation would be lawful either, because you say that it is a predicate to judicial review.
Right.
Okay, which means that, as I understand it, even if there was evident partiality by the arbitrator, you would not get review for that as long as there was no material, gross, or flagrant error.
Well, I understand, Your Honor, that the interpretation that you've pointed out does create problems. I understand that. But that doesn't mean that we're going to change the language to mean something else, because under our Rule 16L letter that we served yesterday, there is case law, and there certainly was at the time of this agreement, where the federal courts were grappling with the concept of, can parties agree, could this agreement have said, and the decision shall be final, and there shall be no review in court, period. There are federal courts that have said before Hall Street that that is enforceable so long as it's clearly set out in the agreement. So there is law for that proposition, but I
That's
understand.
before Hall Street.
Before Hall Street. So I suggest that after Hall Street, they may throw into question whether a condition precedent to court review that would interfere with the statutorily mandated review, for example, for prejudice or other things, whether that's enforceable. But that doesn't then turn that condition precedent into a different standard of review that the court is supposed to apply. So we may have to write out that condition precedent, and in fact, I suggest, Your Honor, that based on the record, you can, because Justice Brady reviewed this case on the merits. And when I say on the merits under Chapter 251. And he also, as an
No,
alternative,
he-
reviewed it under a gross standard.
Yes, he did.
So I suggest that, one, it's not a heightened standard of judicial review, it's a condition precedent. And if there's a problem with that, it's harmless error at this point, because it doesn't matter. But to go to Judge Bosworth's earlier question, if it were a heightened standard of review, what's the current tally? There are 7 states that have said Hall Street applies. That's Maine, and we all know that Maine used to share boundaries with Massachusetts, so I think that is persuasive. Tennessee, Georgia, North Dakota, Illinois, Michigan, and Massachusetts. We have the Massachusetts Appeals Court case just 2 months ago, and this was in our Rule 16L letter that we sent yesterday, that said, in all relevant respects, the language of the Federal Arbitration Act, Chapter 251, Sections 2 and 12, provide for enforcement of arbitration provisions are similar, and we have interpreted the cognate provisions in the same manner. So we do have Massachusetts.
Did that, was the issue in that case whether a different standard of review could apply?
No, it was whether, no, that wasn't precisely before the court.
Okay.
But the question of the enforceability of the arbitrator's decision in that case was, and so the court made that decision, that statement. Now, there are 4 states that have recognized that a heightened standard of judicial review can be enforced, but only one of those states go outside of what I'll call the Arbitration Act parameters, and that's Alabama. The other states, Texas, California, and Connecticut, have all analyzed the situation in the context of agreements that limited the arbitrator's authority, which we all know is one of the criteria under Chapter 251.
Well, but Texas, I read it rather quickly, but I thought it sort of said there's nothing in Hall Street that says that we can't apply a different law on this point, and said under Texas law, we're going to say you can do this.
I think that's right, but if you read the case carefully, I suggest that, but the reason that they're also enforcing it is because they were interpreting that provision as limiting the arbitrator's authority. It wasn't simply saying that the arbitrator had complete binding authority, and when we go to court, we're going to review it for errors of law. It said essentially that the arbitrator was without authority to issue a decision contrary to law. And we may shake our heads and say that's form over substance.
Didn't read the agreement that way.
Okay, but in fact, that's the way lawyers in my position who are drafting arbitration agreements, we all know that the only way you can limit the decision of an arbitrator and get some type of review in court is to limit the arbitrator's authority.
So are you suggesting that if the contract that was between, that was an employment case, right?
That was an employment case.
Yeah, where they took away the award that the employee had gotten. If that language was in this contract, would it be appropriate for this court to say, well, really what it means, it doesn't really go to whether there's an enhanced judicial review, it's really limiting the scope of the arbitrator's authority?
Well, the question would be in that situation, again, as the Texas court decided, can we even read this are we going to permit the parties to fashion essentially heightened judicial review through the mechanism of arbitrator's authority? And I suggested after Hall Street, this court would probably say, no, we're not even going to allow that to happen. Because, and I'll just draw your Honor's attention to Judge Gantz identified, Section 11 of the Mass Arbitration Act, just like the Federal Arbitration Act talks about the court must grant, and then it goes on. And that was what the court focused on in deciding that the legislative intent was only the requirements of the Federal Arbitration Act could be imposed on an arbitration decision. Section 11, again, says, upon application of a party, the court shall conform an award unless, and it goes on and talks about the exceptions in sections 12 and 13. However, even more in section 12, it says the court shall vacate if it has the enumerated exceptions, but then it goes on to say, if these don't apply, again, it reinforces the court shall conform the award. And it says the same thing again in section 13, where it says, shall modify under these certain circumstances, but then it ends by saying, otherwise, the court shall conform the award. So I suggest that the statutory framework, as closely as it is under Massachusetts law to the Federal Arbitration Act, would not permit the court to enforce a heightened judicial standard.
Do you disagree with Mr. Carey that the uniform commissioners, I mean, with the point that Hall Street leaves states to do what they wish?
Well, the uniform commissioners don't have authority over the interpretation of Massachusetts law. And the authors of the Uniform Act realized that this was an issue and realized that they were not going to put it in the Model Act. And so they essentially said, if state legislatures want to put this in, they can. If state courts want to somehow interpret their law based on the legislative text in a certain way, we're not going to impose our will one way or the other. That's all they said.
Okay.
But that doesn't inform us in terms of what the Massachusetts statute requires, particularly in light of the Hall Street decision.
But you would agree that arbitration obviously is a matter of contract?
It is a matter of contract.
And you've got two parties that are contracting with each other, and they can set the terms of that contract. And so how do we square those?
Well, we square it because for reasons, for example, that Justice Lank mentioned, the legislature, for the reasons in Hall Street and the reasons in all the other decisions in Maine, Tennessee, Georgia, North Dakota, Illinois, Michigan, et cetera, they've all decided that the legislature wanted the arbitration process to be streamlined, that they didn't want the courts to be superimposing their processes into that. And more importantly, an additional result, if this court were to allow, and again, it wouldn't allow it under this contract because this is not a heightened standard of review by the court for reasons I've already stated. But as a matter of general concepts, if the court were to allow a heightened standard of review, you would have basically the Superior Court acting as an appeals court, attempting to apply, again, whatever standard that the parties put in the contract, which would be different probably contract to contract, and the court wouldn't have any guidance. That would then subject that process to another level of appeal, in this jurisdiction, at least the Massachusetts Appeals Court. And the process would be even more cumbersome than the standard where you go to court, you get your decision, you have one route of appellate review for errors of law or errors of fact. So I submit that the context of the statute in terms of what the policy was that they were attempting to propose and implement, which was arbitration is a process which is supposed to be streamlined. Often it's not, but it's supposed to be streamlined, and it's supposed to provide finality. And certainly in this context, in this agreement, the parties wanted finality because they said the decision shall be final. And then they did create this condition precedent. And I suggest the intent was to simply say that there has to be something truly important that the arbitrator did wrong before you're going to even get a ticket in the court. And again, if that's suspect at this point, in light of Hall Street, in light of, I understand policy considerations, that even a minor error, if it was the result of arbitrator bias, we may not want to have an enforceable condition precedent to overturn a decision that was the basis of arbitrator error. But that's what the parties agreed to here. And if we're not, and if we're going to not enforce it, it doesn't matter, because the decision's been reviewed by Judge Brady, and he's applied both standards and found that there was no error.
Can I switch topics? The award of attorney's fees by Judge Brady, did it include the fees that went with the claims that were ultimately dismissed and the discovery that went with those claims?
Yes, and there was a hearing on that, and the reason for that, Your Honor, was because Mr. Levine, in his papers, both before the arbitrator and in Superior Court, his defense to one of the claims, the disgorgement claim, was that you can't make me pay for this because my company has it. My company's gotten the money. I don't have the money personally, my company has the money. So when we filed our complaint for confirmation of the award, we added claims against the corporation because Mr. Levine had already represented to the arbitrators and to us that his defense was, it's not my money, it's the corporation's money that we took from your clients. We ended up not having to pursue that because at the end of the day, we obtained a security agreement with Mr. Levine, where after we found that he'd moved money into his wife's accounts, we got those 3 accounts basically attached, and we have a court order protecting ourselves. So at that point, all the issues in terms of having to chase the corporation for the money it had taken that belonged to my client went away. And Judge Brady addressed that issue when they argued that the attorney's fees shouldn't have been for that purpose. And he said, this was simply thorough argument, thorough pleading. And this was all in an effort to, quote, enforce the arbitration award, because the arbitration award was for, among other things, these disgorgement of these fees that Mr. Levine was saying was in the pockets of his company. So yes, the answer is that was part of it. And rely on our brief for the other issues, but bottom line on whether it's 251 standard or material gross and flagrant standard, we have contract provisions that are have been vetted, have been argued, have been testified about by the parties in the arbitration, and there's both arbitrator Judge Williams and Judge Brady found that on the 2 issues that the plaintiffs have raised and made most prominent in their brief, which is the cause versus no cause distinction and how that implicates the damages, and the disgorgement. Those are all essentially subject evidentiary issues, and particularly the disgorgement issue. To correct the statement in the appellant's brief, Mr. Levine specifically testified that he had billed on his new company's letterhead for work he had done at the old firm. So that Judge Williams had evidence that there was work billed from the old firm that Mr. Levine had collected on bills that went out on his new firm. And the accounting that Judge Williams asked for and that we asked for, and what Judge Williams decided had not been provided, was an accounting of what Mr. Levine had collected from clients at his new firm, so that he could determine how much of the money that he had collected from his new firm was really money owed to the old firm. And Mr. Levine absolutely refused to provide any of that information. And so you hear in the record Judge Williams is saying, listen, I've heard from the claimants, you've given me nothing. I have Exhibit D, but all that tells me is what you've agreed that what was billed from the old firm, you've taken in your new firm. But I don't have any evidence of what you've billed in your new firm that you've taken from the old firm. And he says, what am I supposed to do about that? And Mr. Levine didn't object, didn't say he was being improper, that he was inaccurate. There was no objections made. And so under the applicable law, which we briefed, both parties briefed it before Judge Williams made his decision, he was appropriately applying the law of adverse inferences, because Mr. Levine refused to provide the information that would have explained.
All right. I think that's a very long sentence. I was going to give you to the end of the sentence, but not if it's going to be a compound one. So